Good afternoon, everyone. And as Kathy said, welcome to our weekly series. We've got a lot to cover today as usual. And what we thought we would do today is kind of maybe dive a little bit deeper. So, there's been a lot going on with the CARES Act and the regulations issued by the SBA. So I'm going to turn it over to Jeff Shear to get us started today.
Thanks, Pete. Appreciate it. And it's glad to be back on the program today. So last week when I was on the program, I really ran through very quickly the forgiveness application, which had just been dropped by the SBA. And today, as Pete said, we're going to have a little bit more time to look into it. And as the SBA and Treasury has done in a very timely manner, I think it was Friday evening once again. They dropped some additional interim rules and guidance for us. I think that was actually after Treasury Secretary Mnuchin said there'd be no more guidance on forgiveness because there was enough in the application itself. And we received about a 25-page interim rule outlining more guidance on forgiveness. So we're gonna just really get into that as much as we can in the next 15 minutes or so. So the first thing I want to talk about is there's been a lot of talk about loans over and less than $2 million. And we've talked about that in the context of Q31 of the FAQs, which said any loan in below $2 million would be deemed to have been made in good faith. Any loan above $2 million would be under further scrutiny to make sure that they were made in good faith in terms of the initial certification that the loan was needed to support ongoing operations. And that gave a lot of people some comfort, but that doesn't mean that loans that are under $2 million are immune from SBA review. And I just want to really emphasize that today, in that it's still very important for those loans, and there's a heck of a lot of them that are under $2 million that could still be reviewed on a number of areas. One is loan eligibility. Was the entity really eligible to receive a loan? And this is going to look at the size of the borrower, whether they have over or under 500 employees, how they counted the employees, possibly looking at affiliation rules with foreign entities, and how those employees are counted. We had a lot of questions about that early on, and I can certainly see eligibility questions coming up in that context. The amount of the loan could be called into question. So if someone may have overstated or maybe understated their payroll costs for last year, and whether they applied for a loan in the correct amount, that could be called into question and reviewed at some point in the future. And the forgiveness amount eligibility could also be reviewed. And I think the issue there obviously is whether the amount being forgiven is really, made up of 75% payroll costs, 25% utility costs, and whether how you've calculated your payroll costs and your utility costs are really appropriate. Now, we've said all along that once you submit your application for forgiveness, the SBA or the lender has 60 days to turn it around. But that does not mean that all is done at the end of the 60-day period. The SBA really has, I think it's almost 6 years where they could come back and review eligibility. It's really at their discretion to be able to do that. So that's why, and we're going to talk about that in a minute, why it's so important that all your records be maintained for a period of 6 years after the loan is forgiven or after the loan is finally repaid. So that's kind of the initial warning I just want to give in terms of those loans being under $2 million. There are still areas where there could be review of the loan amount, the forgiveness amount, eligibility at some point in the future. If for some reason the SBA determines that you were ineligible to receive a loan, what will happen is, or at least what we expect will happen, has been outlined in the interim rule, is that forgiveness will be denied. The SBA may seek repayment, but that may not be the end of it. There could be other avenues of enforcement. We are expecting additional guidance on this. I have had conversations with some borrowers who've questioned whether they were eligible or not. and asked if, well, if I'm not eligible and the SBA determines that, I'll just return the monies. While we've said this all along, that may mitigate any damages, that may not be the end of it, which is why it's so important to ensure that you were in fact eligible when you made the loan application, that the amount was appropriate, and that you maintain all of your records from when you made the application that supports eligibility and the amount of the loan. The last thing that I want to touch on before I turn it over to Kate is the documentation to be maintained. And I buzzed over this very quickly last week, and I said, just look at page 10 of the application and look at the items that you need to maintain. I wanted to just spend a few minutes today talking about that. There is a tremendous amount of information that will have to be provided with your forgiveness application. There are lots of borrowers that are well into their 4th or 5th week of the covered period. They're going to be looking at making forgiveness applications within the next 4 weeks probably. You probably don't want to be screwing around at the end of 4 weeks, looking for this information. So just to kind of highlight what I think or what is required, and again, it's page 10 of the forgiveness application. One is with respect to payroll costs. You will have to submit copies of bank accounts, copies of tax forms, your 941 that has evidence of all the payroll costs, and payment receipts for health insurance and retirement benefits. So these are all the aspects that are included in your payroll cost, and you want to make sure that you have documentary evidence really tying this all together. So they've asked for both bank accounts and tax forms, not one or the other. They really want to look at the fact that what you show on your bank account is being showed for payroll dovetails into what you have on your tax form. With respect to the FTE counts, your full-time equivalents, we've talked about this a great deal over the past several weeks. You're going to have to provide documentation showing your average FTEs for the covered period. And I think Kate's going to get into a little bit about how those FTEs are counted based on a 40-hour work week, if she doesn't, but they'll just mention it now. You're also going to have your average FTEs for the first 2 months of 2020. Making sure that you have all this information at hand. And the FTEs, I think, is something that's, that I want to note, and Kate may as well, which is based on a 40-hour work week, which may not be how you count your FTEs. You may do it on a 35-hour work week or a 37.5-hour work week. But the Treasury said that 40 hours was the way that they were going to go, and that's how they were going to count the FTEs for this purpose. So it may take some extra time to do that. There is a simplified method of counting every full-time person as a number 1 and every part-time person, no matter how many hours they work, as a 0.5 FTE. That is available to borrowers. But if you're not going to use that simplified method, it's important to take on the, to make sure that you spend time to make sure you're counting your FTEs right. With respect to your non-payroll costs, you have mortgage interest, utility payments, and lease payments. For each of these, it's very important to keep copies of canceled checks, copies of payment receipts, copies of invoices, copies of statements. For your rent or lease payments you're making, to keep copies of your lease agreement and your receipts. You may be having to submit those lease agreements with your forgiveness application. And like I said, utility costs, phone, internet, gas, electric, etc. Making sure you have copies of all invoices and receipts, canceled checks, and statements. So those are some of the highlights of what you will need to provide in terms of the documentation. Like I said, I do think it's very important that you start compiling this information now and you keep a file folder of it so that when you ask forgiveness, you're not running around trying to pull it together at that point in time. So with that kind of highlight overview, I do want to turn it over to Kate Schmelowik, an associate with our business department, and she's going to provide some additional, more detailed information on the forgiveness application. Thanks, Kate.
Thank you, Jeffrey. One of the largest areas of uncertainty prior to the release of the interim rules on Friday was this idea of, can an employer pay an employee a bonus or hazard pay and have that bonus or hazard pay be considered an eligible expense? The Friday guidance that was issued has finally provided clarity on this issue. Bonuses and hazard pay are considered eligible payroll expenses and costs. This means, as an employer, you can pay an employee a bonus during this period and have it be forgiven. However, the application for forgiveness did provide a new $15,385 cap for each employee's compensation that would be considered an eligible cost. Of course, this $15,385 cap is based on the idea in the CARES Act that salaries are annualized capped at $100,000 for forgiveness. So let's dive into a little bit of an example here. If during the covered period an employee is paid $13,500 and the employer wants to provide that employee a $5,000 bonus, they would only be eligible for $1,885 for forgiveness, and that $1,885 would be the eligible portion, because anything over that, being the $3,115, would put the employer over the $15,385 per employee cap that was established in the forgiveness application. This cap and guidance regarding bonuses, making sure the bonuses are subject to this cap, is consistent with the CARES Act idea of having it be under the $100,000 threshold. One of the other new clarifications received in the guidance that we received on Friday evening is regarding the DeMinimis exception to the FTE headcount forgiveness reduction test that Jeffrey spoke a little bit about here a few minutes ago. Previous guidance that was issued by the SBA created this DeMinimis exception for employees who are either voluntarily decide to leave their employment, for employees who are terminated for cause, or for employees who have been furloughed, who then are offered to return to their jobs by their employers and refuse. The Forgiveness Act application expanded on this exception test, as well as the interim rules provided on Friday evening. Now, based on the guidance we received in the application, if an employer decides to rehire their furloughed employees, the offer must be made in good faith, it must be in writing, it must be for the same hours and wages that the employee was previously earning prior to the furlough or the reduction in wages. And now, Friday night's interim rule adds another requirement. That's a reporting requirement. So if an employee refuses this good faith written offer to return to work, and the employer wants to claim the de minimis exception on their forgiveness application to the FTE headcount reduction test, then the employer must notify the state unemployment agency or department, depending on the state, to notify them that the employee refused to return to work. This reporting requirement is new based on the Friday interim rule that was released. And the SBA just kind of plopped it in there with a footnote that says that there will be more information on this issue to be released later. So once we receive that additional information, we will be updating everybody about that. Next, the interim rules and the application that was released created a new idea that payment of expenses outside of the covered period may also still be eligible for forgiveness. So as we know, there are two different types of expenses: payroll expenses and non-payroll expenses. For payroll expenses, payroll costs that are paid during the covered period are included as eligible, and payroll costs that are incurred during the covered period but paid after the covered period prior to the employee's next paycheck date are also included at a prorated amount. For non-payroll costs, a similar calculation is also in effect. So let's take an example, a utility bill. Let's say the employer's covered period is from June 1st to July 26th. During their covered period in June, they pay their May electricity bill that was due in June, and they also pay their June bill that was due at the beginning of July. Both the May and June bills would be forgivable non-payroll expenses. However, they may also pay their July bill, because let's remember the covered period ends July 26th, as long as they pay their July bill prior to the billing date in August, the prorated portion of the July bill that's through the covered period would also be considered a forgivable expense. So what's important here is that it's not the full amount. So it's not a prepayment that's going to be considered the covered expense. It's the prorated portion that's covered during the covered period that would be forgivable. Next, as Jeffrey mentioned earlier a few minutes ago, the application provided clarification regarding the forgiveness reduction tests. There's two forgiveness reduction tests at play in the application. The first being regarding FTEs, and Jeffrey talked a little bit about the two calculation tests based on your 40-hour work week. There's a simplified version now that's come out in the application for 1 or 0.5 for part-time employees. Or you could do the more complicated math equation for the FTEs. That was what we previously thought was going to be the test. This FTE test is really an all or nothing test, aside from the DeMinimis exception that I previously just spoke about here a few minutes ago. For the salary and wage reduction test, there is no obligation for employers to restore wages of employees making over $100,000 on an annualized basis, or again, the $15,385 cap. Additionally, we have now received clarification from the SBA that there will not be a double reduction for employees whose compensation has been negatively impacted as a direct result of a cut in hours. So let's provide another example of that. If an employee has been paid $15 an hour prior to February 15th, and during the covered period is still making $15 an hour, their wage has not been cut. However, they went from working 40 hours to 20 hours during the covered period, then only the FTE reduction test would apply, not both the FTE reduction test and the salary and wage reduction test. The interim rule issued on Friday also provided an appeals process. This is another situation where the SBA plopped this information into the interim rule that there's going to be an appeals process if forgiveness is denied, or if the SBA determines that you weren't eligible for any of these type of eligibility questions, whether it's eligibility for the original loan amount that you received, eligibility for the actual loan itself, or eligibility for forgiveness, will be appealable decisions. However, once again, the SBA added a footnote saying that they will provide more information at a future date regarding the appeals process and what that looks like. There are also, in the same interim rule, also information regarding that if the SBA does have questions during the forgiveness process about a borrower's eligibility, that they will be issuing questions and follow up during that process. So it's not necessarily going to look like it's just the information's provided, the SBA looks at it, denies it, and then you have to move on to appeal. It looks like the SBA is going to review it, and then there's going to be follow-up written questions prior to a denial being issued, and then it looks like there'd be the appeal process. And then finally, obviously there's a lot more here in the rules and in the application. We did send out a client alert that is going to be updated to reflect all of the new guidance that was issued over the weekend that will have more detailed calculations in it. So if anybody else has any other questions, they can, of course, reach out to me or Jeffrey or any other attorney in the business department that they usually work with on these issues. Thank you.
Thanks, Kate. Before we move on to Katie in Albany, I'd like to just ask Jeff if he could, we're getting a few questions here, Jeff, on, the employee count, I guess is what I would call it. People who've been laid off, do they have to be brought back? People who are on leave, just kind of who counts in terms of the payroll protection forgiveness. Can you just briefly address that?
Sure. It's a more complicated question than it seems, which is why I think it's probably being asked. So there are really two periods at hand. One is those employees who were furloughed or laid off, who left between February 15th and April 26th, and whether those people are brought back by June 30th to fully restored by June 30th, as Kate talked about, with a few exceptions. There, we're not looking at individual people, but we're really looking at the FTEs. So if someone was laid off but not brought back, but you hired somebody new, it's counted as a replacement of that FTE. If someone is on disability leave, I believe they count towards the FTE count because disability payments are included, but we'll confirm that before, hopefully before the end of the hour here. In terms of people who are there during the 8-week covered period, you're looking at an average FTE count, and the amount is actually counted per employee. So you're looking at each employee during the 8-week period. If someone is there for 6 out of the 8 weeks, they're going to end up being a 0.75 FTE, if I do my math quickly and correctly. If someone is there for all 8 weeks and they work 40 hours a week for all 8 weeks, they're a 1.0. So you really look at it for the covered period on a per employee, per FTE basis. So hopefully that answers it. Like I said, it's a pretty complicated counting for a pretty simple question.
Yeah, it just reminds me that, a lot of these questions, the Families First Act as well, that these are statutes and regulatory schemes that have been passed quickly that have a lot of detail to them. And so, of course, there's a lot of questions. I mean, I go back to the Family Medical Leave Act, 20 plus years later, we're still sort of dealing with the nuances of that. In any event, these are difficult questions, so we're there if you need us. Let's turn to Katie in Albany. Katie Anderson has been following the events as they unfold daily and weekly. Take it away, Katie.
All right, I'm the second Katie that's scheduled for today, so here we go. Yes, it's been, while we were all taking a nice break for Memorial Day, the state government did not take a break. There was lots of things that have been coming out of Albany. So first things, this is, what I'm going to go through today. We have new executive orders. We have updated guidance. The state legislature is, they're holding meetings today, and they're doing them virtually. And finally, you have, even more guidance about reopening that I expect that'll all change too by next week. So here we go. First thing, looking at the new executive orders, most significantly, Executive Order 202.33 allows for gatherings of 10 or fewer individuals. This executive order does not apply to businesses. It does not apply to, schools. It doesn't apply to places that have already been shut down by other orders. This is for non-essential gatherings of individuals, right? And so Executive Order 202.32 applies the gatherings standard of 10 or fewer individuals to religious services or to funerals. But other than that, just because this executive order exists, Empire State Development has put out that this executive order does not impact businesses that are operating right now. This does not mean that you can have a business operating with 10 or fewer individuals, so long as the other reopening criteria or essential business guidance is not met. Second, another really important part of this executive order is the extending the abatement, and this is 202.33, 3.2, extending the abatement of interest and penalties for an additional 100 days for sales and use taxes due by March 20th, 2020. We're going to be putting out a client alert or an information memo that's supposed to come out this afternoon. It's going to go through all of this stuff. So if you really want to dig into the nitty-gritty of this, feel free to open up your email and take a look at that. And so looking then to the new guidance from Empire State Development about essential businesses. Big first one is vets. Vets and livestock medical services no longer has to be emergency. They can be open. So that is good news for all of us with pets who are staring at you while you're doing this webinar. Next up, we have essential infrastructure. There's more guidance about what campgrounds have to do. And so, you know, for all of you campground operators, take heed of that. And you also have more information about watercraft and what you know, the fact that you can't take out a chartered watercraft vessel at this point.
Hey, Katie,
yeah.
Just real quick. That's essential business guidance. So regardless of phase, is that a correct statement? That
is correct. Regardless of phase, across New York State, vets can be open. Across New York State, campgrounds can be open. Not many campgrounds in New York City, but if there were, they could be open there.
Sure. Thanks.
Yeah, no problem. Happy to clarify. Turning then to the state legislature, it feels odd to be reporting on them at this point since they have not, you know, been in session since the budget passed. But they are doing meetings today. So some of the bills that are, you know, relevant, they're going to be passing, it looks like about a dozen bills in both the Assembly and the Senate. They are all COVID related, and most of them have restrictions on their time, right? So they are only for the expanse of this emergency, but some of them don't. You know, we're looking at the prohibiting the turning off of utility for residential customers during the COVID emergency, prohibiting the eviction of residential tenants that are suffering financial hardship, the requirement to allow people to make applications for forbearance of residential mortgages. Again, we're going to have our information memo that's coming out later today is really going to, it goes through all of these. It provides links in that information memo to the bill. So if it's of interest to you, you can find them there, because I know that bills can be a hard thing to find. You know, also significantly, there's a bill it's likely going to be passed that would extend the Child Victims Act for an additional year. And, you know, that is obviously a big change. And looking forward, you know, we expect that this will either be, you know, all the committees are meeting today. We're expecting that this will, all of these will likely pass by the end of this week. But remember, as of this point, these are just bills. So these are not, they're not law right now. So just remember that. By next week, you know, that slide might say laws in New York now, but not at this point. Looking also at reopening guidance, this slide's a little bit different than it was last week for those regular viewers. The statewide guidelines have been issued, and those are very helpful. It's, you know, for lake and ocean beaches, you know, if you're the operator of those, and for religious and funeral services. it has summary guidelines and the detailed guidelines. I, again, will push in the chat all of those links on the side there so that we don't have to go scrambling for the slides. So when I'm done, I'll do that. But take a look at those. They offer a good indication of where we're going. At this point, there's no phase 2 guidance. And so, you know, many of you likely are in regions that are going to be eligible to enter phase 2 on Friday. That, you know, we expect that guidance will be issued at some point this week, hopefully before Friday. But I expect that those are going to be, they're taking their time on those because they need to get them right. A lot of things are going to be changing with phase 2. The ability to get haircuts is going to be a significant change. So that is, coming down the pipeline. Probably next week I'll be talking all about those two. And so, keep tuned to that. And also remember that today the governor just announced that the Mid-Hudson region is eligible today to begin phase 1. So that will begin, that's beginning today. And then tomorrow, so long as Long Island's rate of deaths do not increase, I believe that was the metric that the governor had today, then Long Island will be eligible to enter phase 1 tomorrow. Looking at the state's grid of where we are for reopening, New York City is very close. So New York City could potentially, looking at the metrics, enter it this week or next week. But sooner than I think any of us anticipated. Finally, and this really bleeds right into the next two topics that Adam and Katie are going to be talking about as well. Just remember, if you're a phase 2 business, really start doing your plan. Even if you're a phase 3 business, now's the time to get that together so that when you do open, you're not scrambling to develop a plan the night before you reopen. Have the plan in place, be ready for that. And with that, I am done.
Katie, thanks. Good segue. We thought we would try to collect some frequently asked questions today on the phases and where we are in reopening. So just to, again, briefly set the stage, essential businesses are allowed to operate subject to, the guidance that's already been issued and is continuously updated by the Empire State Development Corporation. For those of us who are in the reopening phases, in phase 1 businesses, we're sort of working our way through the questions and issues. And then we're also looking forward to phase 2, which will present some new challenges and some other unique issues. And so Adam Mastrolio, Adam's been on before, he's going to talk a little bit about phase 1 and some of the things that people keep asking because these are hard issues. And then we're going to turn it over to Katie Schaefer to give us a little bit in terms of what she foresees for phase 2. Adam, take it away.
Thanks so much. So we have had the phase 1 guidelines now for approximately 2 weeks. And there are a number of issues that continue to come up as we work with our clients in preparing and reviewing their workplace safety plans. All of our clients want to comply with the requirements, but unfortunately, there are some questions that remain unanswered, and we've tried to work with them through some of these issues. So we've gathered the questions that seem to be coming up the most, and hopefully we can provide some guidance for you today. So the question that I think has come up more than any other is what to do if you are an essential business. So essential businesses were allowed to operate before the phase 1 guidelines went in place. But we know when those phase 1 guidelines were released, there was an FAQ that made it very clear that essential businesses also had to comply with the guidelines. The problem with that statement in the FAQs is that not all essential businesses fall within the phase 1 categories. So if you're an essential business, there are 2 possible answers to the question of what am I supposed to do with these guidelines? So first of all, if you are an essential business that falls within one of the phase 1 categories, so for example, you are an essential manufacturer, then the steps you have to take are relatively simple. You have to follow the phase 1 guidelines. You have to create a workplace safety plan that follows the guidelines for your particular industry. And then you also have to read the detailed guidance and complete the affirmation online. The second potential response is if you are an essential business that doesn't fall within one of those phase 1 industries. The answer is a little more complicated here. First of all, you cannot fill out the affirmation that phase 1 industries have to fill out because there is no option for you to select your business when you open the affirmation form. So as some of you may know, when you click on the affirmation form from the state's website, the first question you're asked is, which phase one industry do you fit into? Now it's been the two boating and religious services bullets have been added, but if you're an essential business that doesn't operate in one of those industries, then you cannot complete the affirmation. Second, with respect to a workplace safety plan, our guidance has been that even if you are an essential employer that doesn't fit within one of the categories, you should start working on your workplace safety plan, and we hope you have already. And you should follow the template that the state has provided. We know that in all of the phase one industries, the state used exactly the same template for the workplace safety plan. We also know that the state used the same template for beaches and public beaches and for religious services and funerals. So the state's using this template over and over again. So this is, we think, a good place to start for you. As more guidance comes out, you can adapt your policies to that guidance, but start now. Okay, the next question that we've been getting a lot is, what am I required to do as far as screening, and how do I implement? So first of all, the guidance requires that all employees be screened before they start work every day, and that you also screen essential, quote unquote, essential visitors. With respect to the screening process, the guidance says that screening can take a number of forms. It can be a questionnaire, or it can be taking someone's temperature, or it can be a combination of both. The guidance actually says that best practices, not required, but best practices are for the screenings to take place remotely. So either you have an employee or employees complete the screening online before they come to work, by telephone. Another option that we have seen used is employers will fill out or create a blank questionnaire, give their employees 50 copies of the blank questionnaire, have the employees fill out the questionnaire before they come to work, and then hand it in when they get to work. So one of the goals of the screening, according to the state, is to minimize exposure when employees get to work. So the state doesn't want you to have your employees all congregating in one area while they wait to get screened. So that's why they talk about these remote screening processes and options.
Hey, Adam, real quick.
Yeah.
And again, you stated this, but I think it's worth noting there are options in this area, as there are in many areas, and so yes, people may have a vision of what fits better for them, and these are not really prescriptive in the sense that you must do this or you can't do that. There are things that need to be done. Screening is a thing that needs to be done, but how you accomplish that, you've got some options that will fit, your style, your business, your approach.
Absolutely. And I would just recommend that you work with your bond attorney or other counsel to figure out whether or not you're complying with the minimum requirements at the very least. So for example, we've had clients who have said, well, can I put a poster up at the check-in area? And then if an employee goes to work, then we know that they've complied with the screening because they didn't notify us of anything. And the answer to that is no, that's not going to comply. As far as we read the guidance, it requires an actual screening. And our interpretation is backed up by the fact that the guidance requires the questionnaire or the screening responses to be reviewed on a daily basis and for that review to be documented. So someone needs to be monitoring these responses to the screening questions. So a poster is simply not going to cut it. The next question that we've been getting a lot of deals with visitor logs. So clients have been asking, how do we make sure that we're documenting what we need to be documenting and who we need to be documenting? So the guidance says that all visitors to a facility must be logged with two exceptions. One, customers don't have to be logged, although you can give them the option to be logged if they want. And two, deliveries don't need to be logged so long as appropriate PPE is used or it's a contactless delivery. There are a number of different ways, and Pete just talked about options. This is another scenario where you have options in what works best for you. So how do you want to log visitors? Do you want your receptionist to have a log at the reception desk that he or she fills out every time a visitor comes in? and within that log, do you want the receptionist to be asking questions about the screening questions, such as whether the visitor has had COVID-19 symptoms, whether they've been tested positive for COVID-19 or been in close contact with someone who's tested positive. So you may want to include all that information on that same log. That would essentially kill two birds with one stone, because you'd be screening these essential visitors at the same time as you're logging them. Pete, I'll do one more question because I know we're running late on time. We've received a lot of questions about face coverings, and we know a couple of things about face coverings. We know that the guidance requires employers to provide face coverings to employees. It doesn't say what kind of face coverings, and we know there are a number of different kinds, but if you are an employer and you want to provide cloth face coverings to your employees, the question has arisen, can we require our employees to launder these or clean these masks, or do we have to do it? And the answer is you can do either. You can require employees to clean their masks. However, there are certain things you should be aware of. Depending on a number of factors, including the industry you're in, the type of employee, whether exempt, not exempt, hourly or salaried, and how much that employee makes, you may have to compensate them for laundering these masks. So that's going to be an individual determination on a business by business basis, and really an employee by employee basis as well. So that's another question that came up, and I don't want to keep going on here, Pete, so I'll stop there.
Thank you. That we probably could go on for quite some time because, again, there's just so many questions here, but that's the high level. Let's go to Katie, kind of looking into the future, observations and some of the questions that we're getting on phase 2.
Thanks, Pete and Adam. So if anyone watches any of the governor's press briefings, you'll have seen this one slide he likes to use where he talks about reopening, and it just says the word reopening on it with lots of question marks surrounding it. And it always makes me chuckle a little bit, but I feel like that's actually a pretty accurate slide when we talk about what's next for reopening in phase 2, because we know it's coming. We still have lots of questions about it. So as of this morning, and I just checked again right before this webinar, we don't have any official announcements on the timeline for reopening phase 2, nor have we seen any official guidance documents for phase 2 industries yet. We know they're coming, and we think we may have a good idea of what we can expect in those guidance documents, but we haven't seen them so far. So let's just take a step back so we're all on the same page and we talk about phase 2. Phase 2 industries are professional services, retail, administrative support, and real estate and rental and leasing. There is a lookup tool we've talked about a couple times on the industry's reopening page and the state's website. I would issue caution about that, though. I don't believe that that's always accurate. They may have a few kinks to work out in that. So make sure you're comfortable in the industry that you fall in. I've had some clients put in their NAICS codes, their NAICS codes, and tell them wrong information about when they can reopen. I've searched myself by category for industries that are really clearly phase 2 industries, and the results have popped up that they're clear to operate statewide now. So I would use that tool with a big grain of salt right now at this point. And if you have any questions about what industry you're in, where you fall, and what you can operate, make sure you seek some counsel about that to make sure you're comfortable about that. When phase 2 will happen, the governor said they're going to evaluate those health metrics, and it could be as soon as 2 weeks after phase 1. So it could be as soon as Friday, which is 2 weeks after the number of regions started operating in phase 1 of reopening. We're going to await an official announcement, of course. We can't assume anything is automatically going to happen in place, but it could be as soon as the end of this week. As already mentioned, we don't have any specific guidelines about phase 2 industries yet. All we have to date is guidance for phase 1. And if you'll recall, those came out with a full 24 hours of notice before phase 1 industries were clear to start in many regions. So not a lot of time to review, to digest, to prepare a plan in accordance with them. So what we recommend now is that you start working on your safety plan now if you're in phase 2, certainly, so that you're prepared and you're not starting from scratch, potentially on just hours notice before you're giving the green light for phase 2. And to do that, I think we can use what the state has put out already as guidance. So that's only guidance for phase one, but there are plenty of common elements among them that we've seen despite the drastic differences in those phase one industries. So the retail curbside guidance is very similar to the manufacturing guidance, is very similar to the construction guidance in a lot of ways. So I think we can expect some more of the same there, but at the same time, it'll be important that you review those guidelines that are applicable to your phase two industry and that you make sure your plan's in compliance with them, because there will be some differences. We've seen already some differences in the phase one guidance. So the maximum occupancy rules, for example, the construction does it by person per square foot of space, whereas manufacturing gives a max occupancy of 50% based on your certificates of occupancy. Another example is the retail curbside pickup guidance talks about signage for curbside pickups, staggering pickups times, reminders for customers to use face coverings, touchless payment options, and modifying the retail layout. So those things are obviously very industry specific there. So there are differences meant to address those different risk factors we see in different industries. So I would expect to see some more of that. I think there will be some changes versus the phase one guidelines that are aimed at circumstances that phase two industries operate in, especially since they haven't been released yet, which I presume is not just because the governor likes to build suspense and torture all of us, but because they're making at least some changes to those guidance documents that they've already created. So, as mentioned before, industries like salons, for example, are going to function very differently than manufacturing settings. So there's a lot of different risk factors there, and hopefully some of the guidance speaks to those different risk factors. We know from phase one that it's likely that phase two businesses are going to have to read the detailed guidance that comes out and submit an affirmation online that they've read, that they understand, that they agree to comply with that guidance. That's done electronically at the end of the guidance documents through a link. These have not been released yet, so there's no place for you to do that affirmation as of yet again, but we fully expect that to be the requirement when they do come out. You'll have to do that before you start operating. And lastly, I've had lots of clients asking about bringing people back to work to help kind of ready the workplace before the official first day of reopening in phase two. And I think the answer to the question whether or not you can do that depends on who you're looking to bring back into the workplace and for what purpose. I think if you're talking about janitorial staff back to the workplace with proper PPE to sanitize the workplace, that's very different from bringing people back to organize, to perform administrative tasks, or do any kind of on-site training with respect to any of the new protocols you put in place consistent with your safety plan. So there are some circumstances too where you can have one person on site temporarily to perform administrative tasks. I would caution you that this is a highly fact-dependent analysis, and don't be cavalier about this, and understand that in the vast majority of cases, the guidance contemplates that on-site activities are going to ramp up work, and that won't begin until the first day of reopening. There may be some exceptions to that rule, but those are certainly the exceptions and not the rule. There'll be questions about the specific circumstances, so please review the guidance and talk to your bond attorney if you have any questions about that.
So Katie, I did two things that you said that I think probably bear repeating because we've been getting a lot of questions on it. I'll take the second one first. That the reopening plan and how you get people present to implement it. I think people need to think carefully about that. Again, you drew the distinction between those who are clearly permitted to be there and those who may not be, and others who aren't. So I think we have to really look at the business, what the stated need is, and really carefully analyze that. I think that's not as clear as it might be in some people's minds, because they think, oh, if we're going to open, we have to be able to do something in advance of opening, which is logical, but we need to look at the rules and apply them. But the other thing that I think everyone has said, at least our last three, but I want to emphasize it because we still are getting quite a few questions, that whatever phase you're in, if you're an essential business who was, in this case, never shut down, or if you're in phase one with the industry-specific plans that have been posted to the state's website for adaptation, or if you're in phase two, a coming phase, there are a lot of very common pieces to the reopening plan And we could get started on that today. We could, we get started on that, a week or so ago, because I think we can reasonably anticipate what's going to be in there. At the same time, you point out a lot of unique features that might, around the edges, make those plans different. So I think, the maybe 80% of what's in there is probably going to be almost exactly the same. And then it's that the devil's in the details with the other 20%. But people could get pretty far down the road with the existing plans that are out there as a starting point. Is that a fair summary?
Yeah, I think that's exactly right, Pete. I mean, they're like you said, there's a lot of common elements in there that we're seeing throughout that are likely going to carry over that you can get a really good start on. And I think it makes sense to do that now, to use your best efforts to use what's out there now, and those common elements like physical distancing, required PPE, cleaning logs, and those types of things, and put that together. And then when that that guidance does finally come out, we can use that and fine tune it and say, do we need to make any, additional changes to that, or add anything in, or refine a couple of things to make this compliant? But you'll have a really good start on it so far. So instead of trying to put a complete plan together on short notice, you'll have a really good start and just fine tune a couple things when we do get that guidance out.
Okay, great. Thank you. So I think that's going to do it for us today. We'll be back for the next couple of weeks. At least we're scheduled for the next couple of weeks. I think that's going to be necessary and helpful given the phased reopening here. So thanks everybody for signing on, and thanks for being our clients and friends of the firm. Everybody stay safe out there, and we'll talk to you next week.